Any mention?
Please, Your Lordship.
Yes.
I want to move on unlisted matter. I have mentioned I seek permission from Honorable Chief Justice because the first round of litigation, court number 2 and number 3 has recused themselves. I have made a mention in the court number 2.
What is the urgency?
Because they have closed the proceeding without giving us all the documents and all to submit, Your Lordship. Your Lordship, the bench also won't be available till January. Suppose in the meantime.
Matter is ready.
Yes,
you
sir.
filed
So
it.
I filed.
Okay. Just give a try. Let us see if it comes during sitting.
Your Lordship. May I please, Your Lordship?
Yes.
My Lord, item number 9, hearing. It may come after vacation, my Lord.
Who is the other side, Mr. Chanda?
Mr. Mujika, I have informed my junior to convene.
Anybody for Dr. Mojika? Oh, yes.
No.
Yes, item number 9.
I am praying for after vacation, my Lord.
Yes.
Your Lordship, we are not appearing, Sir Deepnath.
Mr. Devnath is appearing for the other side, Mr. Chanda.
Yes, Your Lordship.
Yes. Item number 9. It will go
Yes,
after
Your Lordship.
vacation.
Yes, Your Lordship, item number 9.
On the request of the learned counsel for the petitioner, list is matter after vacation. It will come after vacation.
My Lord.
Alright. May I please, Your Lordship?
Yes.
I beg to mention item number 6, Lordship.
Item number 6.
Yes, Lordship.
Yes.
Let this. Yes. Due to personal difficulties, Lordship.
You go for
Objection, Your Lordship.
Yes. Item 6 on the request of the learned counsel of the petitioner, list of the vacation. Okay.
Highly pleasant.
May I please, Your Lordship? Your Lordship, I beg to mention item number 13, Your Lordship.
13. 1 3.
I've taken the concern of the other side. They'll come after vacation, Your Lordship. Respondent, Your Lordship.
Okay. 13 also? Same thing.
Highly
The
honored.
request of the petitioner. Okay.
Please, Your Lordship. Lordship, I beg to make a mention item number 7, Your Lordship.
Only item number 7 or more? Only one item? Sure.
Lordship.
Yes.
Lordship, let this matter come after vacation, Your Lordship. Join prayer, Your Lordship.
Who's the other side?
Mr.
Item number 7?
Mr. Sivas.
Why are you running away? Yes, 7 also. Any objection? No objection. You are happy? Yes. Also, this also on the request of the district vacation. Okay.
My Lord, I beg to submit item number 4, my Lord.
Yes.
Prakash Movin. I am praying if the matter can come up after vacation, my Lord. I will inform Sir Dingdo.
It's already informed, Your Lordship.
Already informed? Okay. That land acquisition matter?
In land acquisition, where we brought in the
You have to redo
award
again.
statement.
See, you have to redo again.
Yes,
Probably
we'll have,
this court had this matter once or
we'll
twice.
definitely do it.
But then if there is a gap, then court...
Yes, my Lord.
This court has in fact forgotten.
We'll continue, my Lord.
You do not have to continue, you have to restart.
Yes, my Lord, we'll restart.
Yes, this on the request of the state respondents, this is matter after vacation.
Obliged, Your Lordship.
Please, Your Lordship. I beg to mention item 3.
Yes.
Item 3.
This is also a matter how much writ court can do, how much interference we can cause. Anyway, this is also on the request of item 6. Item 3, sorry.
Item 3.
Item 3, say on the request of the petitioner, district after vacation. Yes.
Lordship, assembly prayer for item 10, 11 and 12.
You are there.
Lordship, yes. Then let it come in the second week of Feb, Your Lordship, because...
Okay. On the request of the learned counsel for the petitioner, this matter in the second week of February.
Lordship. Oblige, Your Lordship.
10, 11 both.
10, 11, 12.
Connected matters.
10, 11, 12. Same counsels.
Yes. I'm from the private.
Okay. Yes.
Supplementary cause list. Item number 1.
Yes.
Your Lordship, I beg to mention to make kindly take up this matter at the bottom, Your Lordship, because the conducting counsel is in there.
At the end of the board.
Item number 2.
May I please?
Yes.
My lord, here my main grievance is that on 12 August 2023, I and my sister were forcibly dispossessed from our homestead and property situated in Sirakhawa village of West Garo Hills district. And on 25 August 2023, I filed one application under section 145-146 CRPC before the ADM Tura. The ADM Tura passed an order and transferred it to the SDM Dadengiri immediately because the jurisdiction lies with the SDM Dadengiri. Now, till date, the application has not been registered, my lord. That is my only grievance. So nothing has happened, and I am dispossessed last 4 months, my lord.
That is in the 145 proceedings. You have filed an application. You have filed a.
Yes, my lord.
For withdrawal of 145 proceedings under 145.
145, my lord.
107 145. Same,
Yes,
by same application.
Yes, my lord.
Anyway, we are not going into.
We'll have instruction, Your Lordship, because I don't know whether.
Issue notice. We'll issue notice.
Lordship, yes.
Interim order may be given so that nobody enters into the
interim order?
property, my lord.
It's not there.
We'll issue notice. We'll wait
Yes,
for
Lord.
these things. In August you have filed.
Yes, my lord.
Then you can wait. Yes, hard, Mr. P.K. Boda. Petitioner. Issue notice returnable in 3 weeks. Mr.
1, 2, 3, Your Lordship.
Gandhi Shulai. Along with
3 is private, I think.
I'll go APS4. There's one number 1, 2,
3 is private party. 1 and 2, I think.
1 and 2, I think, Mr. Shulai.
I mean,
He is a private
3 to 16
individual.
are private
I'm
parties.
looking from my petition, which has.
There is
3
a
has been, Tura ADM has been deleted. Correct. It has been corrected actually.
so it should be 1 and 2.
1 and 2 only.
Here it is 1 and 2.
Yes.
Lordship, my file is 1, 2, 3.
After filing, we had to correct it.
It is very good. Anyway, for 1 and 2, yes, such no formal notice is called for in respect of the said respondents. Stop. The petitioner shall take steps for service of notice upon
Copies,
phone
we have
number
to correct it.
3 to 16. By registered ID within. You take steps within.
Within only 2 days. Within 2
2
days.
days?
Yes.
Within 2 days. List accordingly.
Upright.
Item number 3.
Yes.
May it please, Lordship.
Yes.
My lord, I have prayed for quashing of these criminal proceedings. My lord, the allegations herein is the, my lord, there is allegations that, my lord, some order passed under 144. It has been the defense of the order passed under
Violation of prohibitory order.
I'm at this time, my lord, I'm just praying for notice, my lord.
Yes, madam.
I'm accepting notice, my lord.
No objection to the issuance of notice. Hard, mister. You are challenging some order.
Yes,
passed.
Lordship.
When was this order passed?
Yeah, my lord, the order was passed on 21st/8/2023, my lord.
It's not for time barred.
No, my lord.
Why?
My lord, we have challenged the entire proceedings, my lord.
Is it a revision or original petition?
Come by way of criminal petition, lordship.
Hard, Mr. S. Pamti, learned counsel for the petitioner. Issue notice, returnable in 5 weeks. I'm S. N. G. Shilla, learned senior APS for the for all the respondents. There's no private respondent.
No, lordship.
As such, no formal notice is called for. You'll be filing anything?
We'll seek instructions, lordship, in case of any filing required.
Okay. Is this matter after 3 weeks? In the meanwhile, the learned synergy will obtain necessary instruction.
Lordship. My Lordship. Item number 4.
We placed your Lordship, this is a criminal petition which was withdrawn earlier after making those
I am appearing on behalf of respondent, Your Lordship. We have just filed Bakalat Nama. I pray that it can be taken up after vacation.
Do you intend to file any objection? No.
Yeah, we will respond. We respond to it.
You'll be filing an objection, written objection?
Yes.
You intend to
Your
file an
Lordship.
affidavit? Okay. So service is complete?
Yes, Your Lordship.
Hard. Honored counsel of the petitioner, Mr. L.M. Sangma, enters appearance on behalf of the sole respondent and prays that the respondent may be allowed some time to file an objection in the matter. Prayer allowed. List this matter after vacation. In the meanwhile, the respondent may file he or her, his objection.
He. Obliged, Lordship.
Objection in the matter.
Hearing item number 2.
May it please, Your Lordship.
Yes.
Lordship, in this matter, similar matters is pending before the Supreme Court, Your Lordship.
Okay. Yes. Spending.
So, matter leads to the benefit of fifth pay commission, my lord, but the similar issue is pending before the Apex Court, my lord.
Okay. It's all right. It is submitted with
My lord.
parties that the connected matter pending before the Apex Court is yet to be dismissed too. In view of the submission, release this matter after a vacation.
Much obliged, Lordship.
To
My lord.
come.
My lord, deeply aware, lordship.
Item number 5.
Wait.
May I please,
Yes.
Your Lordship? Your Lordship, my senior counsel, Sir R. Devnath, is not on the court, Your Lordship.
Who is for petitioner?
For petitioner, it's Sir R. Jha, Your Lordship.
Yes, you want to take to some more instruction, Mr. Devnath?
It is not yet has come in instruction because this is last occasion we had thought.
Okay. None appears for the petitioner. Mr. R. Devnath, Lawrence CGC, is present on behalf of the respondent. Yes.
Lordship, this my senior, he is on his legs, so let the matter come after winter vacation.
Just cancel the things on the joint request of the parties. List this matter after vacation. You obtain your instruction in the meanwhile.
Item number 8.
Yes.
Your Lordship, in the last order, Your Lordship, this court has allowed a petitioner to file to take necessary steps, Your Lordship, for implementing the staff-selection committee, Your Lordship. So I had filed a miscase, Your Lordship, for implementing the staff-selection committee, Your Lordship.
Where is that miscase? Where is the miscase? Newly filed miscase. In terms of the order dated 30/11/2000, heard Mr. So-and-so, heard Newta. Mr. Newta.
Yes.
Yes, Land Counsel for the petitioner, and also please give your name for the respondent. In terms of order dated 30/11/2023, this is order in miscase, okay? Miscase 236. Okay. In terms of order, the petitioner has filed this application seeking implement of the Staff Selection Commission as respondent number 4 in writ petition number 316 of 2020. The learned counsel appearing for the respondent has no objection to the prayer made. Stop. From the averments made in the petition, it appears that the Staff Selection Commission is required to be implicated as a party respondent in the case for just and proper adjudication of the matter, or a just and proper adjudication of the matter. Stop. Hence, the application is allowed. The Staff Selection Commission is added as respondent number 4 in the writ petition. Stop. The registry will make necessary correction in the cost title of the writ petition. Stop. The application stands disposed of. In the main case, you write, in view of the order passed in miscase number 236 of 2023, the Staff Selection Commission has been implicated as the respondent number 4 in the instant writ petition. Stop. The petitioner shall take steps for service of notice upon the Staff Selection Commission within a period of 2 days.
Yes.
Stop. List this matter after vacation. See, you have not given any address of this thing, respondent. Only you say Staff Selection Commission. What is the address of Staff Selection Commission?
Sir, I will.
Please verify
Yes,
it when you take
verify.
steps. Yes.
Much love.
Obliged.
Second call, item number 1.
Yes, Mr. Sinkan.
My lord, here I am challenging an order dated 6/11/2023 passed by the executive magistrate under section 145/107 CRPC. My lord, they have drawn a proceeding, and then they have asked the petitioner to sign a bond of rupees 1 lakh. My lord, now
where is that order?
That is
Is it at page 17, annexure 1?
My lord.
This is the order under challenge?
My lord.
Yes, just read it.
CR put up today, seen endorsement from learned ADM East Castles, peruse the non-FIR filed by the concerned IO from the Lightumfra PS. On perusal of the facts of this instant matter, I am satisfied that there is apprehension of serious breach of peace among both parties. Therefore, let notice be sent to both parties to show cause as to why they should not be made to execute a bond of rupees 1 lakh each for keeping the peace for a period of 1 year. For the interim, police authorities of Lightumfra PS are hereby directed to keep a close watch on ground situations and to ensure that there is maintenance of law and order to the area. However, there is no date when to file the show cause. Now,
they have not been ordered. You have only been asked to
file
show.
Yes. Now, the brief facts of the case is that, my lord, it pertains to the plot of land at Fire Brigade ground. That is the Fire Brigade ground that is called Madan Yoringhap. That is the main issue, which is the core issue, my lord. Now, as regard to this particular plot of land, there is already a litigation which has been pending before the district council. And
between the same parties?
Between the same parties. And moreover, the parties has also approached before the Honorable High Court under Article 226 by WPC, my lord, and thereafter the matter went to the
226 in relation to property.
Yes, but initially
the matter is pending before district council.
What has happened in the meantime, my lord? Deputy Commissioner, my lord, Deputy Commissioner passed an order, that is order dated 12 November 2022, page number 21, my lord. Deputy Commissioner, page number 21, my lord, Annexure 3.
Yes.
Deputy Commissioner passed this order. I'll just read out, my lord. In inviting a reference to your letter number so and so, this is to inform you that in view of a number of programs being planned in the Madan Yoringhap, it is advised that status quo may be maintained as far as usage of the ground is concerned, which includes established procedure of obtaining NOC from the Darbar Snam and permission from this office, subject to all other conditions being met. Now, when the Deputy Commissioner passed this order, I am...
Tell her to sit down. Sit down.
You sit, it's okay.
If you stand and then I think that you are about to make some issue. Yes.
Now, my lord, petitioner herein, he is the Rongbasnong of the Limukra Darbar, my lord. Now, the Deputy Commissioner passed this order 12th November 2022, saying that established procedure of obtaining NOC from the Darbar and then obtaining NOC from the Deputy Commissioner's office. That will be followed. The moment this order was passed, the respondent herein, my lord, the private respondent number 5, he came before this honorable court saying that she is claiming to be the owner of that particular plot of land. Now, she came before this honorable High Court under Article 226 to set aside this order passed by the Deputy Commissioner. Now, initially, my lord, the honorable single judge has stayed this order of the Deputy Commissioner. Thereafter, my lord, the Limukra Darbar filed an application for vacating that order. Now, again, thereafter, my lord, the honorable single judge has vacated the order. As soon as the order was vacated, my lord, appeal was preferred before the division bench. And then division bench did not interfere with the order of the Deputy Commissioner. It also held that there is a disputed question of facts. It cannot be decided.
So this order remained?
Yes, this order remained. It cannot be adjudicated in a writ proceeding. Thereafter, the other side was directed, whoever went to the court, my lord, the respondent number 5 herein, was directed, if you have any dispute, then you go to the court, civil court. Then they went to the civil court. They also filed an application for injunction at interim before the district council court. That was rejected by the honorable district council court. Even then, my lord, continuously they have been trying to use the district machineries, my lord, by way of filing complaints one after another.
But then this order is inconsequential, so far you is concerned. You can file one show cause and tell.
No, my lord, here, what is the mistake that has been done by the Honorable Executive Magistrate while passing this order? Now, as per the procedure, my lord, while passing an order for executing a bond, my lord, this covers from 107-116, my lord. Now, as per the procedure which is laid down under 116, my lord, I will just read out if...
Yes.
Before that, my lord, I will read order section 111, order to be made. That is CRPC, my lord. Section 111. It says, when a magistrate acting under section 107, section 108, section 109 or section 110 deems it necessary to require any person to show cause under such section, he shall make an order in writing setting forth the substance of the information received. Now, when he passes an order under section 111. Now, if my lord will come to section 116.
Finish the reading?
Yes.
Substance of information received, the amount of bonds to be executed.
the amount of the bond to be executed, the term for which it is to be enforced, and the number, character, class of sureties, if any, required. Now, he passes an order under section 111. The power is here. And section 116, my lord, if my lord will come, it says inquiry as to the truth of information. Before he passes an order, he has to make an inquiry. When an order under section 111 has been read or explained under section 112 to a person in court, or when any person appears or is brought before a magistrate in compliance with or in execution of a summon or warrant issued under section 113, the magistrate shall proceed to inquire into the truth of the information upon which actions has been taken and to take such further evidence as may appear necessary. Now, before passing an order, my lord, there is a...
No, not before. It is after. It comes, see the first line of this section 6. When an order section has been read or explained under section 112.
When an order under section 111 has been read or explained under section 112
in court
to a person in court, or when any person appears.
It means after the order is passed, somebody appears before the court, and then when the order is read out to him.
Now, another aspect.
So it is not a condition precedent prior to passing of order under one.
Now here, my lord, he has already passed an order saying that you have to execute a bond of rupees 1 lakh rupees.
You may have better grounds.
Yes, and my lord, Honorable Supreme Court, my lord, when the matter has already gone to the civil court, my lord, may kindly come to page number 10, my lord, of my petition. Here I have referred one judgment of the Honorable Supreme Court.
Which one? Ramsumer Puri? No.
No, Muhammad Abid and others versus Ravi Naresh. This is very recent judgment, 2022, my lord.
Where is the judgment?
My lord, I have just referred it here. The relevant paragraph, my lord, I can submit the copy of the judgment. Paragraph 8.
It is better to read from there.
Page number 10, my lord. Here it says,
given only 2 lines. What is the judgment?
Once the civil court is seized of the matter, it goes without saying that the proceeding under section 145 cannot proceed and must come to an end. The inter se rights of the parties regarding title or possessions are eventually to be determined by the civil
court. What happens to 107 then?
Yes. Now, as far as 107, my lord, my submission is, my lord, the next judgment, my lord, which I have referred here, paragraph 9. It says, I'll just read out the relevant portion, my lord. It is under section 107, my lord. Having heard learned counsel for the parties and having perused the record, it does appear that there is no denial to the fact statement made in the applications that necessary inquiry under section 116 CRPC was not conducted before issuance of the order dated so and so. Though the learned AGA would contend that the emergent situation that existed, that conditions to dispense, there is no material as may inspire confidence in the contentions raised by the state. The present applications is allowed, order dated passed by the subdivisional magistrate is set aside. The matter is submitted.
Background is not known. We do not know whether
no, here, my lord,
refers to any initial order or to final order.
No, here, my lord, the similar order was passed. Similar order was passed, but the court said that there is no inquiry which was conducted for passing such an order. Therefore, the court has set aside the order which was passed by the Honorable Executive Magistrate, my lord. As far as section 145 is concerned, my lord, the proceeding, my lord, cannot proceed because already civil court, my lord, which I have already given a detail, that is pending before the district council court. My lord.
That you show the place the judgment. You see, like for 2-3 lines is very.
My lord, I will place the judgment. Now, for now, my lord, I just pray that notice.
Order was passed.
The impugn order was passed, my lord, on 6/11/2023.
November.
Yes.
It's almost. It's more than 1.5 months.
For now, my lord, I pray that notice may kindly be issued, and
notice will be issued.
in the meantime, my lord, this order may kindly be stayed, my lord. Only in the meantime, my lord, but till the next day.
It has been given, and it is already 1.5 months.
My lord, that is true, but till the time, my lord, the matter is decided that otherwise entire matter will become in process.
Please, your lordship, I'm appearing on behalf of Mr. SN. He's on his legs, your lordship. As far as the stay is concerned, I object, Your Lordship.
Why you object?
Your Lordship, I've just received the brief, but
Tell us, can a proceeding, a common proceeding be drawn under 107-145 by one order? Two things related to two different things. And the law requires, there are certain requirements under 145 before a notice is issued. Whether that has been complied with, is there any reflection?
Your Lordship, if this matter can come
We are
up
not
again-
going to any other proposition of law as Mr. Singhon has said.
Yes, Your
That
Lordship.
when a civil court
Yes, Your Lordship.
seizes with the matter,
Yes,
then 145, you see, like in a, these are all, see, like these are what? These are preventive measures.
Right.
Prohibitory orders.
Yes, Your Lordship.
This has nothing to do with the ownership.
Yes.
Okay, the claim of ownership.
Yes, Your
It is only for the purpose of prevention of breach of peace.
Yes, Your
nothing
Lordship.
else.
Yes.
Okay. Now, if matter stands seized by a civil court, can an executive magistrate accessing power under 145 and see that part also, how 107 and 145
Yes, Your Lordship.
He has to record, my lord.
can it be by the same order? Say like this aspect, can a magistrate draw up proceeding under both 107 and 145 in one proceeding? That part also is.
Yes, Your Lordship.
I think he has made out a case for interim orders.
I'll accept notice, Your Lordship, on behalf of 1, 2, 3, and 4, Your Lordship.
Okay, we'll just say, heard Mr. Singhon. State is otherwise not directly affected here.
Yes, Your Lordship.
Why so many state respondents? And you are first party or second party there, Mr.?
I am the second party, my lord.
Your Lordship, the private respondent is also there. You
Notice
have
has to go.
Yes, Your Lordship.
Yes. You have not received a copy of the petition which was filed before the executive magistrate?
No, my lord, nothing.
Have you raised that content on that?
No, my lord, we have received only this order.
No, have you received? You have not raised that plea that you have not been served with a copy of this thing?
In fact, they have to record in the order itself what is the information they have received.
And you heard Mr. Ansakan, Lana counsel for the petitioner. Issue notice, returnable in 3 weeks. Miss Ailingwa,
On
Learned GA.
behalf of Mr. S.N. Your
Yes, Mr. Sen. We are passing interim order in this matter. You have seen the order?
I've seen the order.
Can
Not
a
recorded
145 was 07 be drawn up by one order? This is one aspect.
Lordship.
Second aspect, whatever the requirement of 145 surplus 1, that has not been.
Correct. I've noticed that. Lordship.
Not going into all other aspect, he says that there is a civil matter pending application of this thing. So we are just.
Lordship.
I will so and so accept notice on behalf of the respondent number 1, 2, and 3. And as such, no.
1, 2, 3, 4.
1, 2, 3, and 4. As such, no formal notice is called for in respect of the 3 respondents. Stop. However, the petitioner shall take steps for service of notice open the respondent number 5 by register ready within 2 days. Stop. Pending. Yeah, just it is provided that till the returnable date, the appeal order dated 14th November 2023 shall remain stayed. Will we be having it previously?
Lordship. Yes, because this will only complicate the situation. There is already a civil dispute.
It's unnecessary.
There are certain orders, and this will only complicate.
See the order.
Lordship.
There is no
satisfaction.
adherence to whatever is laid down in CRPC.
And
No suppose notice. Mr. Singhon says that no, even a copy or the basis of information.
Correct. That has not been supplied to.
Nothing has been. Then list after 3 weeks. In the meanwhile, the state respondent shall obtain necessary instructions. I don't think state will have much to say here, but even then.
Supplementary list. WPC 421 of 23, Yaine non-cloud.
It's a writ petition.
Yes.
Yes.
May I please?
Oh, Mr. Paul is there.
My lord.
Yes.
My lords, this is in connection with a judgment and order delivered by this honorable court. My lords, if your lordships kindly come to page 18, my lords, paragraph 17.
Yes. Yes,
My lords, I'll just
page 18.
Page 18, my lords, last two lines of page 18.
Yes.
Well, as WPC number so-and-so is disposed of by directing KHEDC to take a reasoned decision in the matter as to whether the reference in Schedule 2 to the relevant act has been non-cloud ringy or non-cloud. Such decision will be taken...
Wait, Mr. Paul, wait, first. The court has not gone to the relevant part. You are referring to page 17.
Page 18, my lords, last two lines.
Yes. Please.
Paragraph 17, my lords. WPC, your lordships have it, my lords, may I read?
That is paragraph 17.
Yes, my lords.
Yes.
WPC number so-and-so is disposed of by directing KHEDC to take a reasoned decision in the matter as to whether the reference in Schedule 2 to the relevant act has to be non-cloud ringy or non-cloud. Such decision will be taken 4 weeks from the date upon first hearing both the petitioners herein and the respondent number 6 or the authorized representatives. In case the legislative wing, which is deemed to be the appropriate authority to take a call, a select committee of legislators may be formed by the Legislative Council to hear both the petitioner and respondent number 6 or the authorized representatives before taking a final decision in the matter as to whether the Schedule 2 to the said statute should refer to non-cloud or non-cloud ringy. Now, this was the directions that were passed by this honorable court, my lords.
When this direction was passed?
My lords, this judgment and order is dated
27/9. Yes.
27/9/2023.
Yes.
Now, thereafter, my lords, we have been issued a notice by the respondents, my lords, only in the month of October.
You were petitioner or respondent in that case?
No, my lords. I was respondent number 6 in that proceeding.
Okay. Yes.
My lords. So thereafter, my lords, the matter was, my lords, on 30th of October 2023, they issued a notice to us, my lords. Your lordships would find that at Annexure 4, page 24.
Yes.
Well,
it's in vernacular.
It is in vernacular language. Well, it's the
Translate 26.
Page 26.
Yes, sir. Translated copy.
26 is the translated copy.
Yes.
So the matter was refixed on the 13th of November 2023, my lords.
That is a notice to you and to us.
Yes, sir.
Yes.
Now, what is basically why we are before your lordships is, my lords, I had filed 2 applications at page 32, Annexure 7, if your lordships kindly have a look at it.
Yes.
My lords, the first is an application to provide the copies of the written arguments and documents submitted by the petitioners, my lords. That was the Donbok non-cloud ringy before the executive committee. And the second is an application, my lords, at page 30.
No, what happened to this for hearing? Did you appear there on 13th November?
Yes, my lords. I have appeared. The petitioners have also appeared. In the earlier round of writ petition, my lords, both parties have appeared.
Yes.
They have filed certain documents and written arguments, my lords.
Yes.
So I filed an application. I said, kindly provide me with the documents and the written arguments that have been filed so that I can respond to it. Now, both these 2 applications are kept pending before the the respondents. And, my lords, our apprehension is they are trying to dispose of the matter without disposing of these 2 applications filed by us, my lords, at page 32 and 34.
Who is appearing for district council? You have served a copy to the district council.
Because just filed this
No,
morning.
they are the main respondent. State has nothing to do here. Mr. Paul, it seems a copy of the petition has not been sent to district council.
Well, it's
That is, this court will not pass any order, any interim order at this stage without hearing district council. They are not
no,
even.
but I would pray your lordships can only issue notice at this moment, Millets, and we'll serve them a copy.
Okay, that we can do. That will do. Please see, you have to. That was your duty to first to serve district council. State, I don't think you have any role here.
No, state, Millets, I don't think would have a role.
Why state is
Millets,
why state is major party?
Well, it's because the act which is the subject matter of this dispute, was notified by the state.
Anyway, it's all right. Hard, Mr.
Malaj, may I make a alternative prayer subject to what your lordships feel, Malaj? Your lordships, could this matter be disposed of by a limited direction, Malaj, to hear us and dispose of these two applications?
No, but then whether that has been disposed of already or not, we do not know.
Not disposed of, Malaj. Otherwise, there would have been no occasion for us to come before your lordships.
No, even then, Mr. Paul, let district council appear. It will not be proper to dispose of the matter without, since their party, in their absence, not like this. Dispose of.
Malaj.
Lord Mr. Capel, Learned Senior Counsel. Appeal for the petitioner. Issue notice, returnable in 3 weeks. Miss I. Lingua, notice on behalf of the respondent number 1. The petitioner shall take steps for service of notice from the respondent number 2 to 7 within 2 days. 2 weeks.
2 days. Within 2 days.
List after 3 weeks. We'll see.
My lords, if your lordships only make an observation that pendency of this writ petition shall not be a bar for them to dispose of the representations. But my difficulty is, my lords, that otherwise my fear, my lords, I should be candid before
Mr.
your
Paul,
lordships.
see, any kind of interim order.
My lords. I won't press for an interim, my lords. I quite understand what has fallen from your lordship, my lords. It was our duty to serve KGTC. But my fear is, my lords, that while your lordships have issued notice in the matter, if the main matter is disposed of without hearing as well as without providing us copies of this documents, this matter would also become infructuous.
Okay. Issue notice, so and so, till step so and so. Okay. Then, next paragraph you say, it appears from the writ petition that the petitioner has filed 2 applications dated 15/12/2000. 2 applications, both dated 15/12/2023. Both on the same date.
Yes.
Both,
Yes.
So you filed 2 separate applications for almost the same purpose.
No, Your Lordship, one for providing copies and one that
for providing opportunity of hearing.
Yes, after providing us
after copies are received.
Whatever is provided.
Could not have been done by one petition.
Your Lordship.
Could not have been done by one petition.
The more the merrier, Melons. That's why these applications.
What is that? 15/12/2000. Seeking supply of copies of document and documents submitted by the respondent number 6. Before the Deputy Chief Executive Officer, KHDC, and also for affording an opportunity of hearing before the disposal of the matter pending therein. The petitioner contends that the side applications were not entertained. You see, deputy says he is not made a party.
Malaj, the executive committee is a party, Malaj, before your lordships.
And these applications are filed before the deputy executive.
Malaj, he's just the presiding officer, Malaj. That's why it's written as deputy executive secretary.
It is contended that
because the direction was to the executive committee by this court.
Bishop, just tell the last line. Just they said applications. This is the applications. Dated Sharada. Where not been taken into consideration. By the concerned authority. And it is apprehended that the matter would be disposed of without the same being considered. Is that your contention, Mr. That
Well, they will dispose of the main matter without disposing of these applications. They may allow it, they may reject it, but some order would have to be passed, Malaj.
Give a full stop. Give paragraph. In view of the submissions made. It is appropriate. It would be appropriate to provide that the whom shall we tell, you see, whether it should be deputy executive or shall we make a direction to the CDC?
Executive committee, Malaj, because the original direction is to the executive committee to hear us and then pass an order, Malaj. What I pointed out at page 19, Malaj, the direction is to the executive committee.
Last line, just adjust the stage to observe that dependency of this writ petition before this court shall not be a bar for the executive committee of the KHDC to consider the aforesaid two applications filed by the aforesaid two applications filed by the petitioner herein in the event if the same were not disposed of. Earlier. There may be a bit correction. There may be a bit correction here, there, Mr. Paul. But then more or less it will like this. Keep stop. Then list accordingly. Down below.
Highly pleased. Grateful.
Nothing more.